Hello everybody. This is a bit of a sequel to the previous video I made about where I interviewed two Queensland police about their unhappiness about having to impose unjust domestic violence laws. Now I'm really happy today. I've got a former police prosecutor, Richard McDonald. Hello Richard.
Hello.
Who came to me and I think it's very exciting to have this other side of the coin, if you like. Here's someone who is in charge of police prosecution to talk about what his experience has been like. Now, Richard, I've been checking you out. Everyone says you're a really experienced and well-respected police prosecutor. Tell me about that job. How long were you doing it?
I was a police officer for over 22 years. 18 of those years were spent in front of the courts as a police prosecutor, every day at a bar table, presenting cases to a magistrate. Also gave high-level advice in my capacity in the operational legal advice section to all ranks and files of the police force, including the commissioner and the senior executive.
But they didn't always take it. No.
It's only legal advice, I was told. So, not always. Not always,
right. But now you're out. You're a lawyer in private practice.
Yes.
When did you make that move?
In June 22, I resigned from the police force as part of their ODS scheme, and I went into private practice. I literally finished in the police on the Friday, and on the Monday I was at Parramatta Court defending.
Defending, yeah, wow. It's a big shift, huh?
It was one that was a risk, but ultimately I haven't looked back, and I really enjoy being on this side.
Well, because one of the things you said to me when you wrote to me was that you were concerned about what's happening in the justice system, particularly the male victimisation and injustice. So you obviously had an incentive to try to go out and do something about what was happening to men. Do you think men aren't being treated fairly in our justice system at the moment?
Yes, there is a certain injustice there. Just by virtue of them being men, they're often targeted in domestic violence prosecutions, and they make up the majority of the sexual assault prosecutions that occur. And yes, I do believe, and my experience tells me that men are routinely biased against, I would put it in that, in terms of the decision to prosecute,
Yeah, because you described to me how you'd been, in your job, you'd been involved in analysing hundreds of sexual assault matters.
Yes.
To see whether there was a reasonable prospect of conviction. That was your job, right?
Yes.
And that you said in over 90%, your advice was not to proceed. So over 90%, these cases didn't stack up for you. There wasn't enough evidence. And yet you suspect many of those cases did go through to trial.
Yes, although I wasn't personally told one way or the other.
Yeah.
I suspect a lot of sexual assault matters did proceed against my advice, or if they had fixed up their investigation, which was also part of my role, to tell them where the gaps were. If they fixed those up, then the matter was right to proceed. But over 90% I recommended there was insufficient evidence.
Yeah, and part of that was the issue of, in your view, women not always telling the truth. We've got false allegations built in there. That we're talking about a lot of cases revolving around consent. And tell me about some of the patterns you observed there where you felt something wrong here.
I think certainly there is an element of complainants not telling the truth, knowingly not telling the truth, despite being told that if they don't tell the truth, they're liable to prosecution. But there are a number of elements, I think, that come to play in them not telling the truth, and that is, for one, some cultural issues there. Some women may engage in a casual encounter, for example, and that is contrary to their religious or cultural beliefs, and they are then compelled to then make these complaints in order to save face, I would suggest, in justifying that interaction.
Mm.
Others would be that they've been involved in an encounter and then go and seek advice from family or friends or their girlfriends as to whether this was in fact a rape or not, and they have this scrum down, if I could put it in those,
Yeah, right.
and they become convinced. I'm not suggesting that their complaints aren't valid at the time, but they have this scrum down, and the effect of this scrum down is it contaminates their version, which then becomes warped or disconnected with what actually happened, which creates problems when it comes to prosecuting these matters.
That's very interesting, because one of the things I've observed in a lot of the campus cases I've been involved in, it's the friends. And the woman, I mean, some of the girls would say categorically nothing happened, there wasn't a problem. But once they start talking to their friends who say, oh, no, he raped you, you know.
That's
so
right.
That's what this reevaluating of what happened to them.
And there's also this element of this moral judgment.
Yeah.
You know, I don't want to be seen as somebody who's, you know, free and easy, so to speak.
Mistake.
And I made a mistake. I've got regret around this interaction, and, you know, as terrible as it sounds, they're willing to concoct or fabricate a version or reconstruct a version that's not part of their independent memory in order to justify and create this prosecution.
Sometimes when you're talking to them about this, I presume sometimes you managed to convince them it wasn't a good idea to proceed with this.
Mm-hmm.
And if you felt that this was all about regret sex, did they ever show any regret about the fact that they were proposing to shaft this guy?
Lots of detectives that I dealt with in the sex crime squad at State Crime Command would openly tell me that they didn't believe that there were reasonable prospects either.
Yeah.
And that was often reflected in their questions for legal advice. I wouldn't say they had a moral crisis around whether to charge or not. A lot of detectives do investigate to the best of their ability. However, they are somewhat beholden sometimes to how they are directed to.
Yep. No, I was actually thinking about the good women themselves.
Oh, right.
When you're talking to them and you're saying, well...
I don't talk directly to victims.
Oh, you never talk to them. So you've only got the
The
evidence.
The DPP are the prosecuting authority once,
Okay.
so it would be the DPP, but I don't personally interview
No, okay.
the victims.
So you have no idea. But that's what I find so extraordinary is, what the hell? I mean, here's someone you're going to bed with and you have regret sex, and for whatever reason you decide it's better for you to present that as a rape. You never think about this guy going to jail for years? I mean, it blows me away.
Blows me away too. I'm very, it was a very eye-opening for me as a police officer, as an officer of the court,
Yeah.
that there would be complainants out there that would engage in deliberate concoctions or reconstructions. A reconstruction is not what happened, it's in their own mind, what they've managed to convince themselves of what happened
Yeah.
after they've spoken to their friends
Yeah.
or relatives about what happened. They've then reconstructed a narrative which makes it then plausible that perhaps the consent wasn't granted there. There's another element to this too. A lot of matters that I came across involved consensual interactions where there was a persuasion to engage in sex.
Mm-hmm.
Persuading somebody to have sex is not a crime if there's ultimately voluntary interaction and consent. So initially you might get, no, I don't want to have sex, but persistence and then a persuasion to then engage in the sexual act is not a crime.
How did we've got affirmative consent laws, did that impact on that statement you've just made? I mean, the way persuasion is perceived?
Certainly it adds an extra element to the circumstances of how consent is derived and how it occurs. Like most legislation, it's a blunt instrument. Mm-hmm. It cannot explain or it cannot pigeonhole human interactions and the dynamics around how people court. Okay, people court in numerous ways, and ultimately the consent laws, while they seek to create a verbal consent as well as the conduct, ultimately it just, in my view, creates another grey area.
Mm-hmm. But it's not true that if you persuade someone to give consent, that means that the consent they give after that is nullified in some way.
Correct. If consent is later withdrawn or conditional, then and you then breach that, then of course there's a crime.
And if you've used a certain amount of seduction, we used to call it seduction, persuasion, to get to that point, there's nothing wrong with that. But do you think that's how it's interpreted? I mean, one thing what the law actually says, but what the assumption is in the woman's head, what the assumption is in the consent courses we're running, you get the impression that you're not allowed to persuade anyone to do anything anymore.
As I said, it just creates an extra level of complexity to what was operating in the mind of a person at the time, and ultimately I can't read your mind and you can't read mine, so ultimately what are we left with? We're left with the conduct itself.
Yeah, but when this level of complexity plays out with people ending up being convicted, doesn't it? Sometimes.
Yes, I agree, yeah, it does. Individual cases have to be dealt with on their own merits though, so there's not a cookie cutter approach to how convictions occur in this space, but to give some sort of further insight, I'd need to look at a specific case.
Yeah. One of the things you've said to me is that the job of the police is to give weight to the credibility and reliability of the witness, namely the complainant. They have to assess, is this person reliable? We saw this with Brittany Higgins, where the police emphatically concluded she wasn't and decided that Bruce Lambert shouldn't be prosecuted, and the prosecutor, that Jubgold, overruled that, ignored that. Now, you're saying to me generally that is no longer applying. A lot of police aren't giving sufficient weight to that issue.
I think prosecutors. Yeah. Well, I can only speak to what police prosecutors and the sorts of pressures that they experience, and I would suggest that it's probably no different to solicitors in the DPP, that they are under enormous pressure to prosecute matters, especially, incidentally, if they are police defendants, police officers that have been charged. There is significant interest and extra effort made to prosecute these types of matters. Prosecutors will or must engage in that exercise of whether there's credibility and reliability of particular complainants. In the case of Higgins, it's clear that the director, his career ended because of that, because of the failure to properly scrutinise the evidence. In terms of...
Do you think a lot of other prosecutors' careers should end because this is not happening?
No, I don't think that's the solution, to just sack police prosecutors.
I'm just joking, but I'm saying it's rife out there. This is not happening. I could give you case after case of people who've ended up in court or even sometimes being convicted where the evidence was there to exonerate the guy who was
Yes.
being accused, and the police never looked at it. The police didn't want to know.
Well, you're talking about the duty to disclose.
Yeah.
And police do have a duty to disclose not only evidence that assists their case, but also assists the defence.
No, but I'm not talking about the duty to disclose.
Yeah.
I'm talking about that's the second step.
Yep.
That the police have that evidence.
Yes.
And don't make it available to the defence, which they're required to do.
Mm-hmm.
But I'm saying they're not even interested in the evidence. Where I can line up the men here who have been in that situation of being accused, and they had videos showing, her behaviour or what happened on the night. They have witnesses that were never interviewed. They're again and again situations where his case is never looked at.
Well, I'll just put it in these terms. The culture is let the court decide.
Yep.
Okay? That is not the test. The test is whether there's sufficient evidence beyond a reasonable doubt to prove all those matters involving the offence, like a sexual assault.
Yep.
Often I've seen investigations, charges commence, and those charges are then investigated on the run. So people are charged, not necessarily where the case is at its highest, and then the gaps are filled at a later date.
Maybe. I would say. Yeah. I mean, because
I'm not suggesting that that prosecutors are complicit in that deliberately. I say it's a function of their role as prosecutors. They've got enormous workloads. That's no excuse. But in my experience as a police prosecutor, I would go to court and have 6 matters that I need to prosecute in a day.
Yep.
I have to read all those. How closely do you think, in those circumstances, those individual cases will be scrutinised? They often get those matters on the day, and they have no time to properly scrutinise the evidence.
Yep. But that's the prosecutors. I mean, before that is the police.
Yes.
And the issue of whether the police take the complainant's statement as sufficient evidence to proceed, or make any effort to check the validity of that vis-a-vis looking at what he has to say. And we saw in the Sofronoff inquiry, the ACT investigation into Drumgold, the prosecutor who, in the Higgins case, it became very clear that the complainant's evidence has now been regarded as sufficient to go to trial in ACT, but I hear it everywhere. This is what's happening across the country. They're not even giving us stuff about what his evidence says.
Well, taking a statement doesn't constitute an investigation. That's what I've always said to police. You need to drill down on the things that are said in these statements or these recordings, and you need to be objective about that and not just take their word for it. Particularly, I experience that in domestic violence matters where statements or DVECs, as they're called, domestic violence evidence in chief recordings, which are video recordings, contemporaneous recordings of the complaint at the time. They take these recordings or these statements and they don't question them. And that's a function, not necessarily that they're incompetent, but they may not have the time because of their workloads. And that's a travesty, in my view, around justice.
Yep.
The ultimate objective of putting people before the court that need to answer genuine allegations. And quite often a statement doesn't constitute an investigation, which unfortunately is routine.
Yeah, I mean, but that's the culture, isn't it?
Yes.
I mean, the prosecutors, the police, all know that that's what they're being asked to do now, which is let the court decide, push all these cases through. Don't do too much work examining, the reliability of the complainant's evidence. Don't do any work looking at his side of the story, and that's fine. And put it all before the court.
As a defence lawyer, I routinely go to police informants and say, you need to go and get a statement from X, Y, Z, and invariably that doesn't happen. You also,
Defence lawyers.
me as a defence lawyer,
Yeah.
I will go to the police officers
Oh, and say you should.
and say, you need to go and speak to XYZ because it conflicts with the version of your witness. I don't refer to them as victims, I refer to them as witnesses because they're not victims
No.
at that point. They're witnesses for the prosecution. And it doesn't happen. We have to also remember the police force is a military organisation. It's a rank and file organisation like the army. So there's enormous pressure on police prosecutors whose ranks are sergeant, senior sergeants. There's enormous pressure from those above, supers, superintendents, crime managers, assistant commissioners, to prosecute these matters. And I don't know of any police prosecutor, other than myself, that has said, no, I'm not doing that.
You must have been very unpopular.
I was,
How did you survive so long?
by recording, by taking notes, file notes.
By covering your ass, eh?
That's what every good police officer does.
Right.
KISS principle.
Right.
Keep it simple,
Yeah.
stupid,
Yeah.
and cover your ass and keep your job.
Yeah.
Because at the end of the day, you need to justify every decision you make in relation to deciding to put somebody in a dock.
But you're in there telling people they should do their job properly and being uniformly ignored, or not uniformly, but generally ignored.
Oh, look, I don't think I was generally ignored. My advice was respected, and more often than not, it was followed. But on the rare occasion, it wasn't followed, and there was some pushback from senior police. I can give an example. So I was put in charge of a high-profile child abuse material matter, and I asked a very simple question of the police informants who had charged this person. Have you discounted the fact that these productions may have been innocently...
You have to tell us what that's about.
So it was a situation where photographs were taken of children in baths.
Okay.
Daughter was dressed up in...
The man's child in the bath.
Yes,
Yeah.
the father. And the daughter was taken... photographs of the daughter were taken in mum's lingerie as dress-ups.
Yeah.
And these photographs were amongst an array of family photographs. Now, typically, with a child abuse material matter, there will be hidden folders. These would be in hidden folders, encrypted, but these were photographs amongst an array of ordinary family photographs. So I went back to the police officers and said, have we done any investigation around that these are just family photographs?
Yeah.
Why were these photographs taken? And they said we hadn't done any investigation.
So they were going to be used.
And and on that basis, and I said, well, then how do we prosecute this matter if we can't rebut the defence of innocent production?
Yeah.
And I said, this needs to be withdrawn straight away. And the commander of that squad at the time refused to withdraw it. And he said, we don't withdraw these matters simply because we don't have a investigation into a defence. And I said, well, that's an extraordinary thing to say. And then I referred it to my commander, who ultimately had authority to withdraw that matter. And upon that meeting, the matters were withdrawn. So that was an innocent, that was saved. However, they then asked me to then go and do the cost application, which I then refused. And I said, what am I going to say to the court as an officer of the court around a cost application? I'm going to tell the court in good faith that I don't oppose costs because I recommended it be withdrawn. So I was subsequently taken off that and somebody else did the cost application.
Yeah, cool. Yeah. Oh, there you go.
Yeah.
we're talking about, so all these cases being pushed through the court, let the court decide. I've talked before about the eminent barrister Margaret Cunneen, who has spoken out about the fact that she thinks the feminists quite like the fact that all these cases are going to court and a lot of them are failing. She's representing case after case of men being falsely accused of sexual assault. But, of course, the fact that these cases are failing means the feminists can turn around and say our justice system is failing women, we need new reforms. So just today in the paper was a story about new legislation being proposed in Victoria to withdraw the right of to not make it not possible to cross-examine the complainant, witness, in the committal hearing. Now, tell me what you think about that.
I think that's just a fundamental failure for defendants to meet their accuser. The committal stage isn't the trial, though. Okay, but if there are issues around the strength of the prosecution case, then those issues should be allowed to be explored.
Yeah.
And if they're looking to cut that off and leapfrog straight into a trial, knowing that there are credit and reliability issues, then that has a grave potential for miscarriages of justice.
Yeah. And, this is the point, that we're seeing this relentless pressure from the lobby groups to do more to lock men up, to withdraw rights for accused men to protect themselves, whittling away at basic aspects of our...
Well, this represents a fundamental attack on a defendant's right to question their accuser, which is a cornerstone of our criminal justice system.
Yeah.
So chipping away at what I call the principle of legality, these fundamentals, can only be a bad thing, in my opinion.
You said in a way you were removed from what consequences. You make that initial decision in terms of whether to prosecute. You wouldn't usually see what happened to those cases, would you?
No, occasionally I did.
Yeah. I know the injustice was in your head when you wrote to me. Give me some examples of the sort of cases that upset you. What happened in the court? What happened to these families, these men?
Often the family will break down because these are serious offences, sexual assault matters, domestic violence allegations. These are very serious matters and they're viewed very seriously by the courts. It usually will cause a breakup of the family. And these are allegations that have never been tested.
Yeah.
So from the get-go, the male offender will often have to leave the family home. They're excluded by way of an apprehended domestic violence order. They may lose their jobs.
Yeah.
I've had a client who was accused of a domestic violence related offence, and he was charged with some very serious charges like breaking in her, and he lost his job as a result of that. The cost involved is enormous. For a sexual assault trial, on both sides, you're probably looking at around $300,000 for the advocates, the barristers, the instructing solicitors, the Crown prosecutor, their instructing solicitor, the judge, the jurors, the police, witnesses. It's enormous, the cost.
Let the court decide, and taxpayers will pay for all this crap. It's just extraordinary, isn't it?
Well, the scrutiny, because of the consequences of these failed prosecutions, clearly scrutiny needs to be at the forefront of the minds of the people just making the decisions to charge people.
Yeah.
But let the court decide is not scrutiny. No,
but the whole culture is protecting this current system and saying this is the right thing. We need to lock up more men. Not saying is what's happening here reasonable.
Well, men make up most of sexual assault offences. So there is a significant interest in putting those matters before the court because of other interests in our community around having these matters be put before a court.
You said to me, yeah, there are a huge industry of stakeholders pushing the system in the direction it's going. Who are they?
Well, there's a victims' charter. So a lot of groups advocate in accordance with the victims' charter of rights. So those groups are significantly dependent upon government subsidies to exist. So, and these people are not lawyers. They're social workers.
Yeah.
They're psychologists. They're not legal professionals, and they don't necessarily have the training to determine, just because somebody says or makes an allegation, of whether those allegations are credible or truthful.
But they're not interested, are they? I mean, the basic point is they're true believers, believe all women. I mean, I would imagine a large numbers of people in that industry have no interest in determining the truth of the allegations.
Well, I just think there's a lot of cognitive dissonance out there. There's a belief that victims must be victims because they're called victims.
Yeah.
So, but you're right, there is a financial interest
Yeah.
in perpetuating their own services, but they don't necessarily impact the operation of justice.
No.
But they have an interest in ensuring that victims come through
The whole
the
system,
system.
continues. Yeah. We were talking about how would we stop this? At the heart of the issue we're talking about is the problem of false allegations. And that's what's really causing the injustice, I think, that led you to contact me. The fact that, for all the legitimate rape cases that properly need to be addressed and dealt with, with every sensitivity, there are substantial numbers of cases of these false allegations you described earlier. And the biggest problem we have there is the fact that there's enormous pressure, A, to pretend that's not happening, and B, to do nothing about it when it's proved that the woman was lying. Talk to me about that.
So I think there needs to be more consequences for false allegations made by complainants, in which it can be proved that they made false allegations, because when a complainant comes forward and gives the police a statement, everything starts with the police or the detectives. They read the first paragraph, which essentially says that if I tell lies, I'm liable for prosecution.
Mm-hmm.
There's no consequences for lying.
Yeah.
For complainants. The reason for that is that they don't want to re-victimise victims. They're not victims.
Yep.
They're offenders because they've lied.
Yep.
So this whole concept around re-victimise, we don't want to charge victims of sexual assault, even though we know they deliberately lied, is a nonsense.
So you see that really at the heart of this perversion of our entire system, the fact that they're not taking action over false allegations.
Correct. I think it is a form. It's a denial of natural justice for the person accused.
Mm-hmm.
They don't have any recourse other than walking out of a court free, thanking that they didn't go to jail.
Yeah.
That's their reward.
But if they're wrongly accused, they often find they can never get a job again, that they've lost their family.
The stigma sticks.
Huge consequences, even if you're falsely accused. And this is the point. If we were going to do one thing to change the system, do you think that's it? Addressing the issue of charging for people for false allegations?
I think with those particular matters in which it is clear and there is sufficient evidence to demonstrate that they lied and deliberately lied, then yes, that will send a message of deterrence out to the community and make people think twice. But it's a double-edged sword. That is, it may deter legitimate complaints.
Why would it do that? That's what they always say.
Because complainants may often question themselves about whether they were raped or not. And to then add that pressure to legitimate complaints, that what if I end up in the dock, that may be counterproductive. That's the whole reason.
That's the logic. But
Yeah.
surely there's a way of addressing that in terms of...
Well, scrutinising the evidence, that's the way of addressing it.
Also, a woman who's in that situation, who was unsure whether she was raped, but in the end, she probably was. She didn't give consent. She could be supported at that point.
Yes.
To shore her up and to help her through that, rather than allowing everybody who makes any accusation to be believed.
Correct. I think the other way of addressing it is the leaders of our community, the politicians, having the courage to acknowledge there are false complaints.
Yeah.
And to reflect those false complaints in legislation that allow those matters to be prosecuted.
How are we going to achieve that, Richard?
Well, I don't think it's an impossibility, but we need a politician with courage.
Yeah. Or government with courage, yeah.
Correct. So, and our chief law enforcement officer also needs to have courage to acknowledge that not every matter that goes before a court involves a truthful complainant.
Yeah. I'm thinking at the moment that we're proposing to do some political campaigning before the next election, and I've been thinking about what are the costs of the current policies so we can make a cost argument that the current system is ridiculous waste of public money. And of course, here's a classic. And you've talked about, rape trials costing up to $300,000, whatever. That's the top of the head figure. And dozens of these happening across Australia every week, presumably. And a significant proportion wasted money, and then sometimes the police get charged, the Crown gets charged with making a false allegation, false imprisonment or for wrongful prosecution, etc. I think there's a cost argument to be made that the current system is wasteful in the extreme, apart from destroying the lives of thousands of people. Anyway, we're working on that. Maybe you could help me. One, I thought briefly, just sort of summarising some of the issues we've been making around sexual assault. What advice would you give to someone who's been falsely accused of sexual assault? Quick points, 5 top of your head.
Okay. First of all, don't talk.
Okay.
Don't talk to the police until you get legal advice. Do not talk to the complainant at all. So if you get a call out of the blue from the complainant months down the track, do not talk to them. Do not, as soon as that...
Because that's a setup with the police listening, recording that call.
Possibly.
Yeah.
But they could also be in breach of an AVO as well.
Yeah.
By talking to them.
Right. 3?
To write down your notes about what happened contemporaneously and give them to your lawyer so that those instructions are concise, and you're able to construct a defence around that, particularly around the consent issue.
Yep.
I'd advise them to try to remain as fit as possible for their mental health. Try to ensure that their resilience is at its highest, because it's going to be a very tough and long road for them.
Yep.
To seek assistance from a psychologist to help them cope.
If they can find a remotely
Correct.
sympathetic one. I'm very cynical about psychologists.
But most of all, I would suggest that they just ensure that they don't speak to anybody about the allegations, because none of those allegations, if they speak to their family or friends around what's happened, and give a version, that's not privileged. Those communications are not privileged and can be used against them.
Yeah.
So I think the most important thing is for them to just only talk with their lawyer about the allegations.
Oh, can I just on that point, how do you find a good criminal lawyer? I mean, one of the issues that's concerned me for a long time is realising how many duds there are out there. A lot of people, criminal law doesn't necessarily attract the top end of the legal profession, and many of them who are working are extremely, under the pump, taking on too many cases, not doing enough. I mean, so a lot of guys just get really minimal legal support, bad legal advice. How do you know you've got a dud?
I think you need to ask questions of that lawyer. What's your workload? How many sexual assault cases have you actually defended?
Did you win?
Correct. It's just like a job interview.
Yeah.
You need to ask pointed questions about their experience. Luckily for me, I've got over 20 years' experience in these matters, and I can point to many examples where I've been successful, and I've got the added advantage of knowing how the police investigate these types of matters. But how do you ultimately find a good criminal lawyer? A lot of it's hit and miss.
Yeah.
A lot of it's word of mouth.
But it's probably got much more important than choosing a new car or a refrigerator. It's probably one of the most important decisions you'll ever make.
It's probably one of the biggest purchases that you'll ever make, like a house or a car, because it's your liberty at stake. And what price do you put on your liberty if you go away for a decade because of a false allegation? Then you've got all that process to go through in trying to re-enliven the case to prove your innocence, which is totally contrary to our criminal justice system, where they must prove everything.
Yeah. Richard, thank you so much for that. I'm going to come back and talk to you a bit more about domestic violence, but though your insights into the way sexual assault is operating at the moment are really unique. Obviously, your experience is really rare, and I was extremely pleased that you approached me and were willing to do this.
Thank you. It's been a pleasure.
Thanks, Richard.